The Supreme Court has sent a clear signal. It's ready to reshape America's gun laws. In an extraordinary move, the court relisted over 60 gun control cases from across the country, a rare step that shows its impatience with the confusion in lower courts. These cases cover everything from assault weapon bans to restrictions on young adults and non-violent felons. The justices' near-unanimous decision to act signals that the current patchwork of Second Amendment law is unsustainable. The court is preparing to draw new, definitive lines that will impact gun rights for generations. At the heart of the ongoing debate over gun rights in America lies the Second Amendment, a single sentence that has sparked centuries of discussion, legal battles, and passionate arguments on both sides. Its words have been analyzed, interpreted, and reinterpreted by scholars, lawmakers, and citizens alike, shaping the very fabric of American society. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. These 27 words, written in 1791, have become some of the most debated in the U.S. Constitution, with their meaning evolving as the nation has grown and changed. For generations, courts and legal scholars wrestled with a fundamental question. Does the Second Amendment guarantee an individual right to own firearms, or was it intended only to protect the collective right of states to maintain militias? This uncertainty led to a patchwork of interpretations across the country, with different courts reaching different conclusions. Everything changed in 2008, when the Supreme Court took up District of Columbia versus Heller. In a landmark decision, the court ruled that the Second Amendment does, in fact, protect an individual's right to possess firearms, specifically for self-defense within the home. This ruling marked a turning point in American constitutional law. However, the Heller decision left many important questions unresolved. It did not specify which types of weapons are protected, nor did it clarify whether the right to bear arms extends beyond the home. These ambiguities have fueled ongoing debates and left lower courts struggling to interpret the ruling's full implications. As a result, the years following Heller saw a wave of legal challenges and conflicting decisions in courts across the nation. Judges, lawyers, and lawmakers have grappled with the boundaries of the Second Amendment, leading to a complex and often confusing legal landscape. Now, with new cases on the docket, the Supreme Court stands ready to address these unresolved issues, potentially reshaping the future of gun rights and regulations in America for generations to come. In 2022, the Supreme Court's Bruen decision changed everything. The court ruled that for a gun law to be constitutional, it must align with the nation's historical tradition of firearm regulation. This text, history, and tradition test replaced previous balancing tests and put the burden on the government to prove a law's historical roots. The result? Thousands of lawsuits challenging gun laws nationwide, as judges struggled to find historical analogs for modern regulations. The Bruen standard created confusion and forced courts to act as historians, leading to inconsistent outcomes. Now, the Supreme Court faces a flood of cases demanding clarity. The Supreme Court is now facing a wave of cases that reach far beyond the familiar debates over simple handgun possession. In the wake of recent landmark rulings, the justices are being asked to weigh in on a much broader range of Second Amendment issues, each with the potential to reshape the legal landscape for gun rights and regulations in America. One of the most closely watched cases questions the federal ban on gun ownership for individuals who use illegal drugs, including marijuana. Even in states where it's legal for medical or recreational purposes, this case could have sweeping implications for millions of Americans who find themselves caught between state and federal law. Another case challenges Hawaii's unique law that restricts carrying firearms on private property that is open to the public, such as stores and restaurants, unless the property owner explicitly allows it. The outcome could affect how states and cities across the country regulate guns in public spaces. The court is also being asked to decide whether bans on so-called assault weapons and high-capacity magazines are constitutional. These cases strike at the heart of the national debate over what types of firearms and accessories Americans can legally own, and whether such bans are consistent with the Second Amendment's original intent. Both sides in these cases are turning to history, scouring centuries-old laws and legal traditions to support their arguments. The justices must sift through this historical evidence to determine what the founders intended and how those intentions apply to modern society. Other cases on the docket challenge lifetime gun bans for non-violent felons, raising questions about whether people who have served their sentences should be permanently stripped of their Second Amendment rights, or if there is room for rehabilitation and restoration. The court will also consider whether age restrictions that prevent young adults under 21 from purchasing firearms are constitutional, a question that could impact the rights of millions of Americans just entering adulthood. Each of these cases forces the Supreme Court to apply its new historical test to uncharted territory, requiring the justices to balance tradition with the realities of modern life and public safety concerns. The decisions could fundamentally redefine the right to bear arms in the United States, affecting not only gun owners, but also lawmakers, law enforcement, and communities nationwide. Ultimately, the outcomes of these cases will set crucial precedents, shaping the future of gun laws and the scope of the Second Amendment for generations to come. The Bruen decision has led to chaos in the lower courts. Judges in different regions are reaching opposite conclusions on nearly identical gun laws, creating a legal patchwork across the country. For example, one circuit upheld Hawaii's restrictions on guns in public spaces, while another struck down a similar law in New York. Courts are split on assault weapon bans, gun rights for non-violent felons, and more. This confusion is exactly why the Supreme Court is stepping in, to ensure federal law is applied consistently. The court's intervention is now essential to resolve these deep divisions. The Supreme Court's mass relisting of gun cases is a powerful signal, one that legal experts and court watchers have been anticipating for months. This move isn't just a routine administrative step, it's a deliberate action that suggests the justices are preparing to address some of the most contentious and far-reaching questions about gun rights and regulations in America. The sheer number of cases relisted at once is unprecedented, and it's sending shockwaves through the legal community. By bundling dozens of cases, covering everything from bans on assault weapons and high-capacity magazines to laws restricting gun ownership by felons and young adults, the court is signaling its intent to take a sweeping look at the current patchwork of gun laws across the country. Each of these cases touches on different aspects of the Second Amendment, and together, they represent a cross-section of the legal battles playing out in lower courts nationwide. And, by grouping them for review, the justices are preparing for a comprehensive, coordinated approach, one that could resolve conflicting rulings and set a unified national standard. This is not a piecemeal review. It's a strategic move to address the confusion and inconsistency that have emerged since the court's landmark Bruen decision. The near-unanimous vote to relist these cases is especially notable. It shows that justices from both conservative and liberal wings of the court recognize the urgent need for clarity. Lower courts have struggled to interpret the Bruen ruling, leading to a patchwork of decisions and legal uncertainty. Now the Supreme Court is stepping in to provide the guidance that's been missing. This isn't just a delay or a procedural pause, it's the court actively building a docket that could reshape the legal landscape for gun laws in America. By taking this step, the justices are positioning themselves to clarify, and perhaps even expand, the scope of their previous Bruen decision, which has already had a profound impact on gun legislation. The justices are moving from a reactive stance, responding to individual cases as they arise, to a proactive approach, where they can set new, comprehensive rules for how gun laws are evaluated nationwide. This shift could bring much-needed consistency to a deeply divided area of law, affecting millions of Americans and shaping the future of gun rights for generations. The era of uncertainty may soon end, replaced by a new framework from the nation's highest court, one that could redefine the balance between public safety and constitutional rights in the United States. The Supreme Court's next decisions will reshape the future of gun rights in America. If the court sides with challengers, bans on assault weapons and high-capacity magazines could fall, and millions of non-violent felons might regain gun rights. Alternatively, the court could uphold many gun control measures if it finds historical support. These rulings will intensify political divisions and force states to adapt their laws. The answers the court provides will define the rights of citizens and the powers of government for decades. One thing is certain, the coming term will leave a lasting mark on American life.